There we are. We're live.
Are we really?
Yeah, we're up on YouTube.
Hi, guys. Welcome in. Happy Saturday. Good morning, Kai and Chris.
Hey,
Good morning.
Tracy.
How are y'all doing?
Good.
Hanging in there.
Uh,
Hey, Flash fan. Thanks for joining us. We're going to go over some of the hearings that happened this week and then look ahead at the 2 trials starting next week. First, we'll cover Jesse Calhoun. This case is in Oregon. Jesse is charged with second-degree murder times 4, second-degree abuse of a corpse times 4. His victims are Joanne Speaks. She was 32. Her body was found April the 8th, 2023. Next is Bridget Webster. She was 31. Her body was found April the 30th, 2023. Charity Perry. She was 24. Her body was found April 24th, 2003. And then his most recent charge was Kristen Smith. She's 22. Her body was found November the 20th, 2022. He had an arraignment on Monday, August 11th, for the re-indictment for Kristen Smith. And we're going to watch. The arraignment was like 2 minutes. But I figured we would play that. As y'all bear with me as I play that.
Yeah, Flash fan. I don't know why it's second degree and not first. I, I guess I need to do more research and figure out why they decided it was a lesser.
For the state, Todd Jackson, JACKSON, bar number 114240.
Melissa Marrero, MARRERO, my bar number is 123846, also for the state.
Also for the state, Charlie Weiss, WEISS, bar number 220791.
The defendant's present in custody with counsel. This is time, place set for an arraignment. We are ready to proceed.
Good morning, Judge. Cameron Taylor, TAYLOR, bar number 154324, joined by co-counsel Ms. Aschenbrenner.
Good morning, Judge. Shelley Aschenbrenner, bar number 120642. It's ASCHENBRENNER.
All right, thank you. This is the time and place set for the arraignment today on a new indictment. Counsel, can you take me through the process, please?
That is correct, Judge, and I will. Judge, we're in receipt of an 8-count re-indictment in this case. Mr. Calhoun is truly and correctly named. We'll waive any formal reading or advice of rights, reserve all rights under the state and federal constitution, including the right to move against a charging instrument at a later date. We're going to enter a not guilty plea, Judge. We have already previously invoked Mr. Calhoun's right to remain silent, any previous consent to search or seize, as well as his right to counsel at all critical stages. We would simply reassert those rights. So with that being said, Judge, I understand that we have our next status hearing scheduled in this matter for December 5th at 9 a.m. before Your Honor.
All right, we'll keep that date set as is then as the next date for this matter. Anything more for the record?
Nothing for the state. Thank you.
All right.
Nothing from us. Thank you.
All right, we are in recess and off record.
Thank you, Judge.
There's no telling how many he actually killed, unalived.
Yeah, I mean, there's an article that says that 6 bodies were found in the Portland metropolitan area. So, yeah, he's only at this point been charged with 4. And then possibly that 5th one. Who is the 6th victim that was found?
Are you asking me?
Well, I'm just kind of, saying, it's like, who, yeah, it's not on my radar. So now I got to go back.
He reminds me of Rex.
Well, I did, in seeing this, he's either looks very, very tired or like they've got him heavily medicated.
Yeah, he's probably medicated. They're probably scared to get around him unless he's medicated.
Yeah, I mean, he normally has this mean, angry, tough guy look, and here he just looked out of it.
Well, he looked totally different than what I thought.
Right.
I mean, I guess it was last year when they first charged him with the other 3. I mean, he looks totally different now.
Mm-hmm.
Okay, do y'all have any questions before we move to the next one? I'll take that as a no.
Insanity. I don't know.
Yeah, I don't know either. Like I say, it took them forever to charge him. Okay, we'll move to the next one. It's going to be Austin Drummond. The case is in Lake County, Tennessee. He had his first court hearing on 8/7, and it was continued. It took place this past Thursday, 8/14. He's accused of unaliving James Wilson, 21, Adriana Williams, 20, Courtney Rose, 38, Brandon Williams, 15, and this took place on July 29th. He is charged with unaliving ×4, aggravated kidnapping, felony in possession of a firearm ×4, possession of a firearm during the commission of a dangerous felony. The kidnapping charge is for an infant that was found abandoned in a random yard. James Wilson was the child's father. Adriana Williams was the baby's mother. Courtney Rose was the child's grandmother, and Radon Williams was the child's uncle. This is a death penalty case. We're going to try to watch his arraignment. God, it's awful. The sound's terrible. But if y'all decide it's too much, we can just turn it off. And just hold while I get that up.
Yeah, Flashpan, I don't think that that's the teacher.
Like I say, the sound is. People aren't.
All right. Court is now in session. I'm Judge Andrew Cook. Be seated, ladies and gentlemen. All right, folks, good morning. This is our general session docket. August the 13th. I'm sorry, I'm looking at the wrong day here. August the 14th. When you hear your name called, if you would please come to the podium here and take up on the case.
Do I need to make that bigger?
Sure.
If I can do it without screwing something up. No, that's not bigger. Did that make it bigger?
Going over with everybody their rights first, and then I'll get to Mr. Drummond. If you're here today, if you've been cited into court or arrested for any charge whatsoever, you have a right to plead not guilty throughout your entire cause of action. You are presumed not guilty unless you are found guilty at trial. If you are found guilty, you have the right to appeal that case within 10 days to the circuit court. You also have a right to have an attorney be appointed to represent you and also retain counsel to represent you if you qualify. If you wish to have counsel appointed to represent you, the court is happy to ask you questions about your finances to determine whether or not you qualify. Most importantly, this applies for everybody. You are protected by the Fifth Amendment from having to speak or testify about your case, so please don't tell me anything about the facts of your case, or whatever you say will be used against you by the district attorney's office at a later date. With that being said, those are your rights. General, are we ready on Mr. Drummond? Yes. Mr. Huffman, good morning, sir. Good morning, Your Honor. I want to express my appreciation again to you for taking this case. I do appreciate that very much. Have you had a chance to speak with Mr. Drummond?
I have, Judge. We would like to waive the 14-day requirement and we need to set this for further hearing.
Mr. Huffman, what I want to do, if you would accept this and just put as attorney on this form to show that he's waiving the 14-day rule for our records. And I just believe I heard you say you're requesting a preliminary hearing, is that right? Have the parties come up with a date?
We were looking at that earlier. We're good at the court meetings.
General Goodman?
We got set a date.
Well, being that this is a very unique case, I think that this may require a special setting, which goes, on a day that's not Monday or Thursday when I usually have my dockets.
Yes.
I guess my question is how much time are you going to need, how much time are you going to need, General, before we?
Whatever you know today. As I say, Judge, I understand he has things to
That's going to be a circuit court date on the 25th. I've got a juvenile docket that day, I'm sorry. '28th is also the standard day for a docket. And then I know on Friday of that week, I don't have anything on Friday the 29th.
We have a trial scheduled because of the 28th, and it may go into the 29th.
That's all right, I didn't suggest that.
Well, what about
Not September 4th.
that's one of my usual days. I have the general sessions docket. If everybody's okay, I can set it that afternoon.
Well, that's what I was going to do.
Yes, sir.
Send that to lunch.
Is everybody okay with that?
Yes, sir.
Okay. Let's do that then. Mr. Drummond, good morning. I am going to continue your case to September the 4th at 9 o'clock. Sir?
Question. I was under the impression that it was 14 days for the preliminary hearing.
Well,
Is that not?
I had discussed that with him, and I told him that we would be waiting for the 14-day rule and not the 30-day rule.
okay. Mr. Huffman indicates he spoke with you, sir, about the 14-day rule being waived, but not the 30-day rule. So you are entitled to have a preliminary hearing. Now, within 30 days, your attorney is waiving your 14-day waiver. So we're going to have the preliminary hearing to give him time to prepare to represent you in that case. So your case is going to be continued to the 4th of September, and we're going to set that. How about at 1 o'clock that day, guys? Is everybody good with that time?
Yes, sir.
Okay. General, is the state comfortable with that time? Okay.
Judge, we're going to set the other people semi-related on the same page.
Is the state agreeable to setting
Yes,
all
sir,
the
that's fine. Whatever we need to do, I can't do the board. I can do it after. Well, we can do separate hearings. They don't have to be on the same day.
I'm fine to do that, seeing that they're charging accessory after the fact. I don't mind to do that. Court will continue the matter in Mr. Drummond's cases to Thursday, September 4th at 1 o'clock p.m. here in this courtroom. Court will remind Mr. Drummond to keep in contact with his attorney, as well as the previous conditions that the court had entered regarding this matter.
I do have one question about that. The restraining order states in the family members of alleged victims. His girlfriend is one of the family members, and the family has indicated that, Mr. Drummond's family has indicated that she would like to have some contact with his telephone contact. I don't know how the court did it.
Your Honor, we're asking for a restraining order that includes her as well.
And she's already included in the briefs.
Right, and we're asking that they keep.
Well, without having heard any testimony or any proof, or having heard from that family member themselves, I don't feel comfortable amending any restraining order without there being some type of proof or some type of testimony to show that I should do that. So I'm going to continue to have the restraining order remain in place, and that will include all family members until further hearings at that time.
Yes,
So
sir.
we'll continue for that purpose then. Okay? All right, Mr. Drummond, your case is continued to September 4th, 1 o'clock this afternoon. Keep in contact with your attorney, sir.
Thank you, Your Honor. That's all I have for the court. Maybe excuse me.
Yes, sir, and I appreciate you being here. Thank you.
Okay, I can't believe this idiot thinks he can talk to his girlfriend, who is a family member of the victims. That's just crazy to me.
Yeah,
agree.
well, and why would she want to?
Exactly.
I don't know. Yeah, I thought his attorney looked like Chris Wolfenbarger's attorney from Behind.
And there's 3 other people charged with, they helped him, or I mean, they didn't help him. They helped him after the fact. But I didn't include them today because, like I say, this sound was terrible.
Yeah, the ones that supposedly helped him kind of escape or hide or.
Okay, I guess we'll go to the next one. Any questions before we do?
No, I'm good. I'm sorry. The phone was staticky, so I was trying to sort that out.
I mean, he'll be back in court on September the 4th at 1 o'clock. Drummond will. Okay, the next one will be Andrew McGain. I think that's how you pronounce his last name. This case is in Washington County, Arkansas. Andrew was charged with the unaliving of Kristen Brink, 41, and Clinton Brink, 43. This happened on July 26. He fatally stabbed them while they were hiking with 2 of their children. The children's ages were 7 and 9. They were in an Arkansas state park. He was apprehended 5 days later at a hair salon in Springdale, Arkansas. He was in court Thursday, 8/14, for his arraignment. Prosecuting attorney Brandon Carter said he does not plan to waive the death penalty in this case. No media was allowed at the hearing. The next hearing is a status hearing on 11/14 at 8 a.m. I do have a news clip of them talking about their arraignment.
Joining us live in the studio with the latest.
Emily, you're right. We have many unanswered questions about today's hearing.
Come on.
Emily Moss. First now, the arraignment of Andrew McGain was held earlier today. Restrictions surrounding the hearing are raising more questions than answers about this case. 5 News reporter Bo Russell was there and is joining us live in the studio with the latest.
Emily, you're right. We have many unanswered questions about today's hearing at the Washington County Jail for McGain's arraignment. Let's take a look at the footage we got from the jail. There was a court order posted on the door prohibiting any form of recording in or around the courtroom. The window on the door leading into the courtroom was covered with black paper, and the TV that McGain's very first hearing was broadcast on was never turned on. When the defense left the courtroom, they refused to answer any questions. Washington County Prosecutor Brandon Carter was inside the courtroom. He confirms to us that the arraignment was held as scheduled, but he did not offer a reasoning for why the arraignment was not available for public viewing, and says that decision was up to Washington County Circuit Judge Joanna Taylor. I was finally able to get through to Judge Joanna Taylor's office and asked what the reasoning is for why the court order to restrict viewing to the arraignment was placed. I was told that no information will be shared about ongoing cases, but according to Arkansas Code 1610-105, the sittings of every court shall be public. Arkansas Code also states a court must articulate and be specific as to why a courtroom has been closed to the public. As of now, I've received no reason as to why this arraignment was made private. I'm going to continue to ask questions today, and I've reached out to legal experts about the legality of this decision. I'm Bo Russell, 5 News.
Yeah, that was the thing. I was just from the looks of him, it's like, and he was tentatively hired to be a teacher in Arkansas. It's like, what?
Oh, I know. Gosh.
Yeah, I have to wonder, like, what he looked like, like prior to this, because his picture is just kind of like, that's a teacher. Wow.
Yeah, evil, evil, evil. But and also,
Yeah.
what was he teaching? What's his credentials? That yeah. Ugh.
Agree.
I would homeschool my kids.
Oh, sure.
Okay. Okay, we'll go on to Sean Mickey Steins. He's the sheriff in Kentucky that shot the judge, Kevin Mullins, in his chambers on September the 19th, 2024. Strange case to me. They were really great friends, just don't know what happened to lead to the shooting. There seems to be a lot of corruption in the county. Docs are extremely hard to get into Kentucky, so hopefully more details come out about this case as it moves forward. He was in court yesterday for a motion to dismiss indictment and motion for bond. Okay, I don't know if y'all have seen, I'm sure y'all have, but we're going to watch it again anyway. The shooting in the chambers. I mean, they block a lot out at the end, so it's not bad. I swear I'll get better doing this. I just, ugh.
You're good, Trace. You're doing good.
I hear you, girl. You're too sweet.
I guess we can't give Bob too much crap for his tech wizardry.
Well, he's been doing it longer than me, though.
Yes, he has.
God, I wish this had sound. Because I would really like to know what they're saying.
Right. I know. Yeah, that's Kentucky. Okay, he's using a cup, so he doesn't necessarily have an ashtray. But yeah, I want to go work there. So you can smoke in your office.
Like I say, they said that judge, I know he had like civil suits against him. Or the sheriff's department had civil suits, excuse me. Because obviously they were getting sexual. I better shut up. I don't know what I'm saying.
You're fine. I am just curious, like you said, I wish there was sound because with him going through the judge's phone, I feel like he had to have found something in it that like set him off.
Right.
Like I don't necessarily like seeing this. I don't necessarily know if his intent was to go in there and um, do what he did, or if whatever he found in the phone is what set him off. I'm not really sure.
Or what did he say right here that once he showed his gun, it's like, what did the judge say to him that was like, okay, that's it?
Mm-hmm. Yeah, like the judge had said something that set him off. Not that that makes what he did is okay. You know what I mean? But
Right.
I'm gonna shut up. Yeah, I don't.
Well, and people were saying that he went to his office and got his gun before he went to the judge's chambers. So he kind of had some inkling that.
Yeah, that kind of shows intent.
Right. Are you still with us, Flash fan? I mean, I was going to show the hearing from yesterday, but do y'all want to watch it?
Is the sound better than it was yesterday?
Well, I found it. I sped up to where the sound gets straightened out. It's like 9 minutes in. The sound on Law and Crime got better. I don't know if it did on Court TV or not.
I mean, we can just for people who are gonna watch on the replay who haven't already seen it.
Okay. Well, let me work that line.
Yeah, I mean, it's the whole point is, I mean, you're supposed to let law enforcement take care of these things. And I mean, I guess he's the sheriff, but still, you can't be judge and jury, even if you are the sheriff.
Exactly.
I mean, I just think it's got something to do with his daughter somehow, some way, but I could be wrong.
Yeah.
Yes,
Flash fan is still with us. Sorry. Go ahead, Chris. I'm sorry.
Oh, no, I was just going to confirm that yes, supposedly, yeah, this was after lunch. But yeah, what did he find on his phone, and why did the judge just give it over to him so quickly?
Yeah. Somebody yesterday was saying that he called his aunt when we were trying to figure out what he was doing on the phone or whatever.
Yeah, I think I saw that in comments that he was
Yeah.
calling his aunt or something. Which, okay, but why is he using the judge's phone to like what is he looking for in the judge's phone while he's talking to his aunt? If that made any sense.
Or if the judge may have had something on him. I don't know. It's just
right. It definitely could be the other way around. Who knows?
Okay.
And I don't think that it was enough of a heat of passion incident to warrant what he did. You know, regardless of whatever the judge may have done in all these alleged crimes, it didn't look like enough of a heat of passion incident to me.
Right.
Yeah, no, I agree because he was talking to him, I'm assuming calmly ish, you know what I mean?
Right,
In the moments
right.
leading up to it.
Right. And it's not like he found a victim with the judge or, something.
Right.
Like I say, hopefully we'll learn more. Because God, he hadn't had a hearing in forever.
Yeah, it's been a while.
Yeah. So hopefully more stuff will come out. Kentucky's just, phew.
Well, I know. And then it's, also scary. I mean, that they're saying they want to use a mental health defense. And it's like, well, he was the sheriff. I mean, that's scary.
Yeah.
Yeah. Very scary. I mean, he's got a right to whatever defense, but I don't see it as insanity unless we're just not. Obviously, we're not getting the whole picture yet, but like, we got to be missing something if they're trying to plead insanity or whatever,
Right.
Okay. Like I say, this is like, I want to say 8 or 9 minutes in when they finally figured out the sound was all screwed up.
Was the grand jurors, first of all, they spent nearly half the time asking questions. And a large portion of those questions concerned the mental health of Mr. Stokes. And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation is going, and the answer is yes.
I promise the buzz and quit here in just a second.
Stamper testified to that. Now, first of all, probably not an appropriate thing for Mr. Stamper, Detective Stamper, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts. And I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse opinion. And so, this is what I believe. I believe that had they not been told by is very real. And
there we go.
I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him. And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You cited those in your brief.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking. Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, then we'd ask me to put on.
Sure.
Thank you, sir.
Ms. Dahl.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. And we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is the power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time. There was no witness. There was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were the grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
And as an officer of the court, are you representing that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes,
There
Your Honor.
was no peripheral commentary or anything of that?
No, Your Honor.
Just,
Specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Mr. Steele, you
Just a point of clarification, if I understand your question, as you can imagine, nobody in the grand jury room needed to be told what case this was or anything regarding the fact.
I would think that's a safe assumption.
When we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health records. They began asking questions of which we did not have an answer to.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point in time, the preliminary hearing had already been had. The video was already out. Other videos had been released. There was nothing we added at all to, or any conversation regarding the case other than the investigation and why we needed the records. That would have been it.
Go ahead, Mr.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear based upon the rules of criminal procedure that we acted in compliance with those rules. We have additional arguments as far as in the Jackson case. However, the Commonwealth does not believe it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stamper testified to in questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceedings. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. Hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stamper's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor. Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording. And so we do not believe that an evidentiary hearing is recorded. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleadings submitted as well, Your Honor.
Thank you.
Your Honor, may I just briefly reply, Your Honor?
Briefly, yes.
Yeah, Judge, so I mean, I haven't heard anything. I said from the beginning, Judge, I understand, we're talking about the rules of evidence. The reason I cited to the issues where there were things that normally.
Oh, God, what happened?
What did you do? I'm kidding.
What happened? I didn't do anything. I didn't touch nothing.
Is it paused?
No.
Try
They wouldn't
blooping.
come in is because
Never mind.
there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting.
That's not unusual, Mr. Potter.
Oh, I get that, Judge, but my point is this, if you put that into context with what they let testify, then I think ultimately, Judge, if we put on that evidence, will show you that this grand jury was misled. I mean, the statement, to be honest with you, the statement alone, rendering an opinion on saying it is completely, in terms of, I get you don't have to be an expert judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should have been admissible or not. That I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, I'm not talking about relevance, but if it's germane, it's their grand jury. It's not common grand jury. They're the investigative body. And so the reason I cited to the things that I thought shouldn't have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. And that's why we're asking for the.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury. I'm going to listen to the recording, and I'll be happy to review that.
And Your Honor, if the Commonwealth
Briefly,
may.
sure.
Thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat
Understood.
versus a wooden
Sure.
stick. I don't think, there's nothing even alleged in the pleadings, even if you take everything in the pleadings that's been said today by the defense as true, that would be tantamount or even close to that, Your Honor. As far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of grand jury. That hasn't been raised since by the defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I will get an order out on that. One, if I need to hold an evidentiary hearing in it. If not, I will on it appropriately and distribute that. After review, I've got the CDMS Madam Clerk, place that under seal with the conclusion of the hearing. I am going to take a copy of it with me to review for purposes of reviewing the pleadings.
Yes, sure.
All right, next in regards to the bond hearing.
Yes, Your Honor.
Barbara.
Again, Carrie Bartley for Sean Steins, Judge. And we filed our motion for the court to, and it's been back quite a ways now that we
Sure.
filed that, but we did ask the court to kind of hold
Which is
off.
not abnormal. I know we've had some procedural things and evaluations, so
Absolutely.
that
And
is
that's-
something that had to be done
We asked the
first.
court to hold off on setting it for an
Absolutely.
evidentiary hearing until after we received that report back. Judge, I think by pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We have some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Steins is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond in light of the circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at, is what he could reasonably post. We would propose.
Public safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be $50,000 cash for property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Steins, and again, without waiving any of our, any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be.
Oh my God.
Oh, did you just get in trouble for screen sharing?
What did I? Okay, we're going to move on because I don't know. Maybe I did.
What does it say on there?
An error occurred. Please try again later.
Oh no, I don't know what that is, but it isn't. I think the stream would have went down if we got in trouble for screen sharing.
Okay, well, nothing really happened at the hearing. I think they have by next Friday to get something to the judge, and then they'll another hearing.
Yeah, I don't think he made any decisions. Like
No,
he didn't make a ruling. So another Judge Bev.
Oh gosh.
Yeah. PTSD from her. Ms. Wildtide is not on panel. Just so you know.
Right.
Okay, I didn't. Okay. I
Oh,
wasn't
is she
making sure.
back?
Oh, I don't know.
Maybe she is. Hold on. You can add me back. Yeah, she's back.
Yeah. Okay.
Yeah.
I wasn't sure. I just saw that she wasn't there, and I just wanted to let you know. So she wasn't hanging back there.
Okay, for that case, you can follow Hillbilly Crime on YouTube. She's local there, and I think she has a lot of videos about the case. Maybe that's what I need to catch up on.
Flash Fan says that he's going to schedule.
Yeah, they said something at the end about both lawyers have to get something to him, I think, by next Friday. And then he'll schedule the next hearing. Okay. That's good. going to look at next week. We have 2 trials starting next week. The first one that starts Monday with jury selection is in Florida. It's Alicia Andrews. She's 26. She is charged with first-degree premeditated unaliving for the unaliving of Charles Jones, a.k.a. rapper Julio Fulio. Jones, 26, was shot and unalived on June 23, 2024 in an ambush attack while celebrating his birthday in Tampa. She is one of 5 defendants. She is being tried separate from the rest of them, which their trial will be next year. The other 4 defendants are facing the death penalty. She had a hearing, I think it was on 8/13. She was dealt a setback in court when a judge ruled her attorneys won't be allowed to introduce evidence of domestic violence at her trial. Her trial is expected to last until around August 29th. Can y'all hear me?
Yeah, I hear you.
Okay, just checking. My earbuds was doing something crazy. And
Yeah,
I do have a video of the shooting.
Oh, damn.
Yeah, I can say that. Shooting.
I think so. I really don't know.
Well, we'll find out when we get all these.
You get all these emails like you can't say this or that.
Okay.
I really think they're more strict on channels that are monetized, but
Right. Okay, this is a picture of her. And the other 4 were all males that were arrested, 2 of them brothers. Her boyfriend is the one she was trying to get I guess she's trying to say she had to help because of domestic violence.
yeah,
But that's not being allowed now.
that kind of makes. Go ahead.
Go
Sorry.
ahead. No, go.
Oh, I was just gonna say that kind of like makes more sense in my brain that it because her brothers are the other defendants. Because you know how brothers are, but I mean I don't know. I feel like when it comes to certain defenses, I feel like however someone wants to defend themselves should be allowed, but maybe that's just my ignorance of not knowing the law very well. Oh yeah, we can watch the shooting. No, sorry.
Well, there's no sound, so you can talk.
Oh.
No, but I can't. So my sound's on. But
I hear you now.
Okay, there we go. Okay.
So talk.
Too late now. I had to get my corded earbuds because I don't know what happened to my other ones.
Driver!
Oh.
Open the car door!
Sounds like sound, Trace.
Let me see your hands! Step on out! Step on out! Look away! Back up to the sound of my voice! Yep. Stop right there. Lift your shirt up. Turn. Do a 360. What? Just listen to us. We'll talk about it. Keep going. Keep going. Turn. Turn. Now walk back to the sound of my voice. Come on. Keep coming. Keep coming. Keep coming. Keep coming. Keep coming.
Pull your pants up.
Keep coming. Keep coming. Keep coming. Walk back to me. Hands behind your back. Hands up! You're good. Come on out. Hands up. Put your hands up. Target. Can't tell. Your target? Yeah, it looks like it. Yeah. Yep. Put your hands up!
Okay,
Let's
sorry.
go. Right here, right here. Walk right here. Let's go. Yeah.
Walk this way, listen to the instructions.
Yeah. Hey, keep your hands up and walk out towards me. Hey, over here. Come this way. Over here. You're going to get hit with the less lethal. Get your hands up and walk towards me. Hands up and walk towards me. Hands up and walk towards me. Keep coming. Keep coming. Keep coming. Keep coming. Keep coming. Keep coming. Stop. Stop. Turn around. Keep your hands up. Turn around.
See,
Hands up,
too
keep your
many
hands up.
commands.
Hands up. Don't reach for your waist. Do not reach for your waist. Back up to the sound of my voice. Back up to me. Don't look at me. Back up to me. Back up. Back up. Back up. Back up. All right, go to your knees. Put your hands behind your back. Stay there. Don't move. Isaiah? Isaiah?
And come out, we have a warrant for your arrest. This is the Jacksonville Sheriff's Office.
All right, contact at front door. Come on out, put your hands up.
Put your hands up.
Put your hands up. Walk to the sound of my voice. Come on, walk to me. 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 Keep walking, keep walking, keep walking. Keep walking. Now turn around. Put your hands behind your back. Is there anybody else inside?
And the kids, please, like, tell them stop recording. I'm talking about the broadcast. Come right now.
Do, 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 do. Are we still here?
Yes. Can you hear me?
Yeah.
Now, the last guy, they caught all four of those, like, I want to say in July, but the last guy they didn't catch until January.
Okay.
And he didn't get very far. You would think from July to January, he would have been long gone, but
Yeah, I think they don't. I think they start. What's the word? Feeling good and like that, like they got away
right.
instead of continuing to like flee. I don't know. I don't want to give anybody pointers, but leave the country if you can.
Oh,
Like,
what?
okay,
Get a
it's a-
one-way ticket to Vietnam?
It's a Vietnam. Yes. Exactly.
Okay, next we'll talk about Donna, and I'll let Kai do that.
Oh, yay. Okay. So, Ms. Donna Adelson, aka Grandma Gotti. She is being charged with first degree conspiracy to commit first degree unaliving, solicitation to commit first degree unaliving. Donna will have a motion hearing on Monday, but we are unsure of the time as it hasn't been added to the docket. And then jury selection starts 8/19, so Tuesday. And then opening statements are expected to start August 22nd. And testimony is expected to last until September 8th. And then Tracy can show her awesome graphics.
Right on, right on. Okay, we have
Boy,
these.
the 22nd is my sister's mother's birthday.
Oh, Lord. Is she going to be home?
I don't know.
Okay, for anybody that really don't know a lot about the case, I've created these to help you catch up on it.
Can you zoom in?
Oh, God, no, okay, I cannot.
Okay, if you can't, that's fine.
Let me see, hon.
I mean, I'm good. You can also get them in Discord. I know. You can also get them in the Discord if you're having trouble viewing it right now.
Right.
My bad.
I don't think I can zoom in.
Okay.
Well, hold on. Is that bigger?
I don't know. I was reading chat. You're fine. I mean, if yeah, or if you can post it on the community tab afterwards if you want. If not, they can get it in Discord.
Right. Like I say, I don't know if it just got bigger. It said open in browser, but
I don't really think so.
okay, well, we have these in our Discord. If you would like to view them, it's free to join.
She lies. You owe me like $100 to join. I'm kidding.
We have a timeline of, like I say, this case is 11 years old. I mean, he was unalived July 18th, 2014. We've had 4 people that's already went to trial and been convicted. We had Luis Rivera, Latin King name is Tato. Sigfredo Garcia, Latin King Tuto. Katie McBanawa, and then Donna's son, Charlie Adison. We're hoping Wendy will be charged next. We'll have to wait and see. But everything we've discussed today, you can find docs on all the cases in our Seeking Justice Discord. We just hit 700 members a couple of days ago, and we're just really thankful for all of them. We have several of them post our link in their chat. Really grateful for that. And we mentioned last week that we were going to cover this trial, but unfortunately, somebody else had better plans for us. So we're hoping that we can at least do recap shows. And as soon as we find out a time for Monday's hearing, we're going to try to cover it. Thank you guys for joining us today. Y'all got anything y'all want to talk about?
Other than I'm excited Donna's trial is on its way.
Oh, I am too. Unless something happens Monday and it gets delayed.
Tracy, why would you wish that kind of evil upon us?
Well, you just never know with these Adelsons what's going to happen.
I know, but that just, I don't know. Judge Everett really meant business, I feel like, when he said there'd be no more delays.
Knowing her, she fired her lawyer Friday, so now it'll be delayed while she gets a new attorney.
She'd have to fire both of them, I think. I think if she just fired one of them, Edward would be like, well, this other person's up to speed. You know what I mean? I don't know.
All right. Well, I guess that's about it. Unless y'all have something else. Go on. Talk.
I know. Well, it sucks because I don't have my good mic and speakers or whatever. But yeah, I mean, I think Donna was more mad about the divorce and the custody stipulations than Wendy was.
Oh, God,
I
agree.
Yeah, I don't think if Wendy would have had only say maybe 20% custody, I don't think she would have really cared.
Yeah,
I
I mean,
agree.
as it was, she was already putting them in like daycare for most of the. I mean, they both were putting the children in daycare all day. I guess I get that's probably for work. So never mind.
Right.
I forgot
But
that.
yeah, I mean, Donna was the only one that was mad about it and telling Wendy, okay, well, you got to do this and you got to do that and let's do this and let's do that. It's like, whoa, hey, slow your roll, lady.
Yeah.
Right, especially with like the semi knowledge that we have about how she was meddling in Rob's for like relationship. Like
Right,
I don't
right.
know.
Well, and she told Wendy who to marry also.
Mm-hmm. Like I don't.
I hope Rob testifies.
So do I. I would love to hear what he has to say. But I also don't think Miss Wendy is innocent. So I don't want anybody to think that that's what I'm trying to say. I think she's guilty of sin.
Well, I don't think she is innocent, but I don't think she had as much to do with it as Donna and Charlie did. I think she was kind of just okay, yeah, that works for me, so I'll go along with it. But I
can see that.
I think she had knowledge, but I don't think she really had any part of the planning. And I think that knowledge, though, was what gave her the idea to drive past the crime scene.
Yeah, to kind of see if it really happened. Maybe.
Yeah.
Right. But then, like everybody's been saying, it's like, okay, so something happens on the street and you still don't call the father of your children to say, okay, yeah, you.
Like, hey, is everything okay at the house?
Yeah.
What was that? I'm kidding. Yeah, or to even, I mean, as far as we know, we don't even know at what point she asked about her children.
Well, right. I mean, supposedly Dan sent her a text message that said he dropped the kids off at daycare.
Okay.
But still, I would still have asked, hey, what's going on your street,
Yeah. Yeah, no, indeed. Because even if, yeah, especially if she like drove past because it was a shortcut. I'm sorry. Even if I.
Right. Yeah.
Yeah.
It is no shortcut.
Yeah, no, I saw I think it was.
And she lived there long enough.
Yeah. Sorry, I got distracted with chat. His power of attorney cousin isn't paying his attorney. Wait, who? Oh. Go ahead, Chris. That's for a different case.
So
well, Tracy has left us, so I think we're stuck up here.
For now.
Yeah.
Until she kicks us out. Yeah, I think they will have a hard time proving it against Wendy, but I bet they have more evidence, like, in the weeds or whatever you want to call it,
Yeah, I mean,
But
because what they had like what 800 emails to go through. But I know there's a lot of emails. Um,
yeah,
because
yeah.
I almost feel like they have from like Wendy's side they have
But
Donna's
again,
emails, but we don't have Wendy's responses to those emails, if any. And I'm wondering if the Wendy's responses might have been on Donna's computer, if that makes sense.
well, but I think Wendy was smart enough to know not to talk about it at all.
Well, no, I didn't mean like the murders. I meant like the responses to Donna's Unhinged, like the
Right. Well, no, there were some responses, but yeah, I don't think as much has come out that
right.
we want to, but
Right. And if I am remembering clearly, I think Wendy did say she didn't respond to her mom.
well, yeah, I mean, she just way too overbearing and controlling. And so, yeah, I mean, I could see where it was almost like a separate thing. Wendy knew what was going on, but she didn't have any part of it. It was just her selfish mother. This is what she wanted.
Yeah.
And then the thing with Javi.
Do you think he's still at the airport?
I don't know. No. But I think he was probably even more oblivious to the situation than Wendy was. And
yeah, I don't think Harvey really.
He was just the money bags in the whole situation. Donna's spending money and whatever, and he don't know what's going on. He's doing his thing, and yeah, she's got all this. Yeah,
No, that's how I feel.
I don't think.
I feel if anything, he knew afterwards.
Yeah. Well, yeah. After I don't know. Maybe up until the point where Charlie got indicted.
Oh, where Harvey didn't know anything?
Right.
Sorry.
Because they could have just played stupid and, oh, yeah, it's all these hitmen. Oh, look, they caught the hitmen. Oh, and still he could have just been oblivious.
Right. No, I agree.
I know. Where is Tracy to shut this down?
She is having issues. There she is.
Okay.
Trace, can you hear us?
Oh.
Does she not know she's back? No, she's. I just texted her just in case she can't hear us.
Are you? At least it wasn't my sister's mother that called.
Oh, yeah. Yeah, I don't think she can.
Okay,
Go ahead.
Going back on that other situation, the whole thing with the grand jury, I mean, yeah, it's kind of a little shady because they do only get to hear the one side of the evidence. And basically what it is the prosecutor or the state trying to see if, say, the average public will think that there's enough evidence to charge this person, or if this person is guilty, essentially, of committing the crime that they want to charge them with. The good part about the grand jury is if they can't make the grand jurors who see the one side of it believe that the person is guilty, then the grand jury doesn't indict. And so, I mean, I guess then that's where you get, you know, you don't have the threat of false, you know, charges,
right,
against somebody. But yes, hearing just the one side of it, of course, I would say probably, you know, okay, and I'm going to go low, 80%, but probably more of the time, the grand jury does indict.
Yeah.
Now, I know one of the cases that we had before us when I was on the grand jury, we told them, no, there's not enough evidence at this point. We want to hear from these 3 other witnesses or involved parties to see what they have to say before we,
I'm sorry.
you know, decide
I'm
if
back.
this is actually worthy of, you know, running this guy's name through the mud, you know, and slandering him. So, you know, I mean, I think there's good sides and bad sides. But again, since you're only hearing from the defense, and most of these cases that we see on TV, if we only saw, well, yes,
It's
sorry.
okay.
Kai was correct.
Yay, for once.
But, you know, yeah, most of these trials that we watch, if we only saw the state's case against the defendant, you know, yeah, most of the defendants would be found guilty.
Oh, for sure.
And so, you know, of course, that goes to the thing then that you can indict a ham sandwich. I mean, it's, yeah, most likely they're going to get an indictment, but I guess there's that little bit of a chance where, you know, if people are really paying attention and know how it's supposed to work, it's like, you know, no, the state hasn't proven it to the grand jury. You know, that.
Right. No, I get what you're saying. Tracy, back with us? Or did we lose you again? Tracy is having technical issues, guys.
I'm
Tech
back.
wizard.
I'm sorry. Can
You
you hear me?
Yes.
Oh my God. Okay. Well, I think I'm going to end it now.
Yeah, it's fine.
Unless y'all are talking about something.
No, I think we were about done. We were filling the air while you were missing.
Yeah. I think I need a better computer for this. My computer just, I can't believe it didn't end the stream. It just totally went black.
Yeah, no, I don't think it ends when it does that. It's just stupid. But thank you everyone who watched us. And when we know the time for Donna's hearing, we will hopefully be able to stream that for you guys. And check out the Discord.
Yes, and everything Kai said is not legal advice.
Yeah, no. Anything I say is entertainment purposes. Don't take me seriously. And Tracy's underwater.